A federal court just dropped a bombshell, issuing an emergency order that has thrown Donald Trump's legal team into total chaos. The implications are huge. This isn't just a small setback, it's a ruling that could completely change the way Trump's lawyers handle multiple cases and could put them under intense scrutiny. The timing couldn't be worse. Trump is already juggling 4 criminal indictments, numerous civil lawsuits, and a high-stakes presidential campaign. And this order landed late on a Friday, what legal insiders call take out the trash time. A moment meant to bury bad news. But this story is too big to hide. Since leaving office in January 2021, Donald Trump has been facing an avalanche of legal problems. But his lawyers have been experts at slowing things down, complicating every case, and keeping the courts tied up. From the start, they have used every trick in the book, challenging jurisdiction, questioning evidence, demanding delays, and attacking the credibility of judges and prosecutors. Their goal was clear: delay, distract, and defer any trials until after the 2024 election. Trump's legal strategy has never been about proving innocence or building solid defenses. It has been all about running out the clock. His team's approach was to create endless legal chaos, filing motion after motion, delaying discovery, appealing every decision, and overwhelming prosecutors. The hope was that if Trump could push trials past the election, a second term could give him control over the Justice Department, potentially wiping out federal criminal cases entirely. They tried this in every case, whether challenging the special counsel in the classified documents case, claiming absolute presidential immunity for the January 6 investigation, or fighting over privilege claims. Trump's lawyers may delay their weapon. They turned the legal system into a shield, using every loophole and gray area to protect him. But now, this emergency court order has ripped a massive hole in that plan. A federal judge has called out Trump's lawyers for potential misconduct. The order demands that documents and communications they tried to keep secret be handed over immediately. This isn't just a rejection of legal arguments, it questions the ethics and honesty of Trump's entire legal team. The judge's words are harsh, suggesting the attorneys may have broken professional rules and possibly even committed criminal acts themselves. The ruling is a game changer. It goes beyond one lost motion or minor setback. It threatens the very foundation of Trump's defense across multiple cases. There could even be professional consequences for his lawyers, including possible disbarment. Finally, the courts are pushing back against the endless delay tactics that have frustrated the legal system for years. When a federal judge questions whether lawyers are acting in good faith, the consequences can be long-lasting and severe. This could be the moment when Trump's wall of legal protection starts to crumble. Trump's attorneys have always been united in one mission: delay, obstruct, and protect him at all costs. Their strategy is simple but ruthless: never admit fault, attack the prosecutors and judges, claim every investigation is politically motivated, and use every legal tool to slow things down. They've made every case as complicated and drawn out as possible. Whether claiming presidential immunity, arguing he had full authority over classified documents, or asserting attorney-client privilege over communications that might show criminal activity, Trump's lawyers pushed the limits of legal advocacy. Their actions were so bold, sometimes even shocking, that judges started questioning whether they were following basic ethical rules. Everything came to a head 2 weeks ago. Federal prosecutors filed an emergency motion accusing Trump's legal team of hiding key evidence and misleading the court. They claimed some documents marked as attorney-client privileged actually contained proof of ongoing criminal activity. This is critical because the law doesn't protect communications that are part of a crime or fraud, the crime-fraud exception. Now prosecutors were saying Trump's lawyers may have helped him hide evidence, coached witnesses to lie, and made false statements to investigators. These aren't small accusations. They suggest obstruction of justice by the lawyers themselves, raising the terrifying possibility that they could face criminal charges. This situation shows exactly what happens when a client treats the law like a game instead of a system to respect. Trump has a long history of using lawyers as fixers, people to protect him no matter the rules, rather than advisors. That approach always catches up with you. Lawyers who compromise their ethics to please a powerful client often face serious consequences, and now Trump's team is seeing that reality unfold. The emergency order came out last Friday around 6 p.m., blindsiding Trump's lawyers. This was unusual, signaling that the court feared evidence might be destroyed. The order labeled their actions potentially sanctionable and suggested there is preliminary evidence that communications between Trump and his lawyers may have aided criminal activity. The language was damning. The judge basically said these attorneys might have crossed the line from advocacy into complicity. This was not a secret decision. The ruling was public, complete with detailed findings that will stay in the permanent court record. It sent a warning to all lawyers: misconduct will not be tolerated. The response was immediate and frantic. Within hours, news outlets reported Trump's legal team in emergency meetings, scrambling to comply. The order demanded specific documents and communications within 72 hours, leaving no room for their usual delay tactics. The judge also appointed a special master to review the materials, determine what's truly privileged, and decide if sanctions or disciplinary actions are warranted. If courts decide that Trump's communications with his lawyers furthered criminal acts, it could seriously undermine his ability to mount a coherent defense. It also raises questions about his claims that these prosecutions are politically motivated. Trump's history with lawyers shows a dangerous pattern. He treats them as tools, loyal when useful, abandoned when they become liabilities. Michael Cohen, his longtime attorney, handled sensitive matters like hush money payments. Cohen was loyal to the end, but when investigators closed in, Trump left him to face prison alone. Rudy Giuliani, once celebrated as a national hero, became Trump's personal lawyer, leading the effort to overturn the 2020 election. Giuliani's wild legal tactics and public claims eventually became a liability. Now he faces disbarment, lawsuits, indictments, and financial ruin. Trump largely abandoned him. Many other lawyers involved in frivolous election lawsuits also faced sanctions or suspensions. Trump's current legal team now seems to be following the same dangerous path. Their focus on shielding Trump at all costs may have pushed them beyond ethical and legal limits. And if anything goes wrong, history shows Trump will protect himself first, denying any wrongdoing and blaming his lawyers. The pattern is clear. Complete loyalty to Trump can put a lawyer at risk of professional ruin while he saves himself. Last night's emergency order shows something important. Courts are increasingly willing to hold Trump's lawyers accountable when they cross the line from aggressive legal defense into potential criminal activity. The message is clear. Being Donald Trump's lawyer does not protect you from professional or legal consequences. So what exactly did his legal team do to provoke such a harsh response? It all comes down to a pattern of misrepresentations and obstruction. Trump's lawyers tried to shield almost all communications between him and his team from disclosure, even when prosecutors believed those communications involved planning and carrying out criminal acts. After reviewing the evidence, the judge sided with the prosecutors. The court found that Trump's attorneys had made false claims about the content of documents and communications they labeled as privileged. As officers of the court, lawyers are expected to act responsibly, but Trump's team took an extreme approach. They claimed attorney-client privilege over thousands of documents, far beyond what is typically allowed. Their goal seemed simple: bury prosecutors in litigation, make them fight for every single piece of evidence, and delay trials indefinitely. At first it worked. Discovery moved slowly. Prosecutors spent months battling over documents, and trial dates kept getting pushed back. It looked like Trump's team was successfully running out the clock. But then things started to unravel. Prosecutors began spotting patterns suggesting that Trump's lawyers were not being truthful about what was in those privileged documents. Evidence emerged showing that Trump and his attorneys had discussed moving and hiding classified documents after a grand jury subpoena. There were communications showing lawyers helping him craft false statements to investigators. Witness testimony suggested that lawyers were present during, and may have participated in, conduct that could be obstruction of justice. Some statements to the court were directly contradicted by evidence gathered by prosecutors. Even as Trump's team insisted on broad privilege claims, prosecutors built a strong case for the crime-fraud exception, a legal principle stating that attorney-client privilege does not protect communications made to commit or plan crimes or frauds. Courts rarely invoke this exception because attorney-client privilege is fundamental to the legal system, but when lawyers cross the line and become participants in illegal acts rather than advisors, the privilege disappears. Prosecutors now had enough evidence to argue that Trump's attorneys had gone from representation into active participation in criminal activity. Then, Trump's lawyers made a potentially fatal mistake. Instead of addressing specific allegations with detailed responses, they issued blanket denials and accused prosecutors of political bias. They ignored the substance of the evidence, relying on rhetoric rather than facts. The judge was unconvinced. The evidence was detailed, specific, and corroborated by multiple sources. The pattern suggested Trump's attorneys had helped him obstruct justice. Any legal team participating in hiding evidence, coaching witnesses to lie, or making false statements forfeits the protection of attorney-client privilege. This left Trump's legal team in a nightmare. On one hand, they needed to prevent disclosure of communications that could destroy Trump's defense and potentially incriminate themselves. On the other hand, they had to comply with the court's order and maintain some ethical pretense. They could not defy the judge, destroy evidence, or continue misrepresenting facts without facing severe consequences. Producing the documents would likely devastate Trump's defense and their own careers. Refusing to comply could lead to contempt of court, criminal charges, and disbarment. Either choice was catastrophic. This crisis highlights what happens when lawyers allow themselves to become participants in a client's criminal conduct instead of upholding professional independence and ethics. Trump demanded absolute loyalty and his attorneys pushed the limits to protect him, but now they are facing devastating consequences. The court made it clear, loyalty to a client does not excuse unethical behavior. Lawyers who cross that line will be held accountable. The fallout is shaking Trump's broader legal and political operation. If his own lawyers could face criminal charges or lose their licenses, every current and potential attorney must reconsider whether representing Trump is worth the personal and professional risks. The stakes are no longer just about legal strategy, they are about survival, ethics, and the harsh reality of the justice system finally pushing back. Trump's lawyers are now living in fear. Those trying to balance fighting aggressively for their client with protecting their own careers are terrified about being the next to get caught in the crossfire. They've watched Michael Cohen go to prison. They've seen Rudy Giuliani's life and career destroyed. They've followed other Trump attorneys face sanctions and disbarment. And now, this emergency court order threatens to expose more lawyers to criminal liability. Meanwhile, the most loyal Trump supporters in the legal world demand absolute obedience. They believe attorneys should do whatever Trump wants, no matter how unethical or illegal. Anyone who prioritizes their professional survival over total loyalty is seen as weak. They want lawyers who will fight to the bitter end, no matter the consequences, viewing this court order as judicial persecution that must be resisted. Things became even more intense when reports surfaced that some of Trump's attorneys are considering withdrawing from his cases because of this emergency order. Withdrawing from representation during criminal cases is serious and requires court approval. Lawyers can only withdraw for valid reasons, such as a client insisting they break the law. If Trump's lawyers start filing motions to withdraw, it would be catastrophic for his defense. It would publicly signal that even his own lawyers believe he is asking them to act improperly. It would leave Trump scrambling for new representation with trials approaching and reinforce the idea that he is impossible to represent ethically. When attorneys who have defended you for months suddenly try to leave, it shows the situation has become unmanageable. The emergency order came from Judge Tanya Chutkan, who is overseeing Trump's federal January 6 case in Washington, D.C. Judge Chutkan has consistently refused to tolerate delay tactics or legal games from Trump's team. She has repeatedly rejected attempts to push back trial dates and dismissed many of their outlandish legal arguments. She has made it clear that Trump will be treated like any other criminal defendant. The order demanded that Trump's lawyers produce specific categories of documents and communications within just 72 hours. This includes communications about handling, moving, or concealing classified documents, discussions about witness testimony or cooperation with investigators, communications about creating or presenting false information, and documents showing attorney knowledge of potential criminal conduct. The 72-hour deadline is extremely aggressive, leaving no room for the usual slow-motion legal maneuvers. Normally, producing such materials takes weeks or months with extensive negotiations over scope and privilege. By imposing such a tight schedule, Judge Chutkan signaled she does not trust Trump's lawyers to act in good faith. She fears evidence could be destroyed or altered if they have too much time. The judge also appointed a special master, a respected former federal judge with experience in complex privilege disputes, to review all materials Trump's team claims are privileged. The special master has broad authority to investigate whether privilege claims are valid, interview witnesses, and review related documents. If misconduct is found, the special master must report it to the court and potentially to bar disciplinary authorities. This creates an independent check on Trump's legal team that cannot be influenced by politics. The ruling's language was unusually strong. The judge noted sufficient evidence to establish a prima facie case that communications between Trump and his lawyers were made in furtherance of criminal conduct. She said the pattern of alleged conduct could constitute serious obstruction of justice and that attorney-client privilege cannot be used as a weapon to facilitate ongoing crimes. She expressed grave concerns about the candor and good faith of the defense counsel. Words like that are devastating. Federal judges rarely question lawyers' honesty in such blunt terms. This opinion will follow Trump's lawyers for the rest of their careers. It will be cited in future disciplinary proceedings, referenced in other cases, and make other judges skeptical of these attorneys in future matters. Prosecutors in other jurisdictions will point to it as evidence that Trump's team cannot be trusted. The court expedited the case unusually, reviewing the evidence privately and issuing the order immediately without waiting for a response from Trump's team. This shows how urgent the situation is and how compelling the evidence must have been. Judges rarely bypass normal procedures unless the risk of obstruction is high. By acting first, Judge Chutkan prevented the possibility that documents could be destroyed or sanitized. The implications extend far beyond the January 6 case. The documents likely contain information relevant to other criminal cases, especially the classified documents investigation. If they reveal Trump and his lawyers discussing how to hide classified documents or craft false narratives, that evidence could impact multiple prosecutions. Prosecutors in different jurisdictions share evidence when investigating related conduct, meaning this one order could ripple across Trump's entire legal landscape. Legal experts from all sides of the political spectrum have weighed in. Even those generally supportive of Trump have expressed alarm about the conduct alleged. Constitutional law professors note the crime-fraud exception is well established, and if the evidence supports prosecutors' claims, the privilege assertions were clearly improper. Ethics experts warn Trump's lawyers could face severe professional consequences, including disbarment. Conservative scholars have said that helping a client hide evidence or coach witnesses would be one of the most serious violations of professional responsibility, deserving the harshest sanctions. The consensus is clear. This isn't partisan spin. The legal community recognizes that fundamental ethical standards may have been violated in ways that threaten the integrity of the justice system itself. Now let's look at what this emergency court order could mean for Donald Trump's legal situation and his political future. This isn't just a dramatic legal development. It has real consequences for his criminal cases, his ability to defend himself, and his 2024 presidential campaign. First, the immediate impact on his criminal trials is huge. Trump has been desperately trying to delay all his trials until after the 2024 election, hoping that a win could let him influence or even end the federal cases. But this emergency order, with its demand for rapid document production, could speed up trial timelines by resolving privilege disputes that have been holding things up for months. The evidence prosecutors might obtain could give them their strongest proof yet of Trump's criminal intent. If communications show him discussing how to hide documents or obstruct investigations, it would be devastating to any defense that claims mistakes were accidental or based on legal advice. This is a nightmare scenario for Trump's lawyers. Most defendants rely on prosecutors having to prove intent through circumstantial evidence, but if Trump's own words document criminal conduct, prosecutors have direct, irrefutable evidence. That makes convictions far more likely. Politically, it's a disaster too. Democrats and Trump's opponents are already using this ruling to reinforce their narrative that Trump believes he is above the law. They point to the fact that a Republican-appointed judge, with no partisan reason to rule against him, found the evidence so compelling that an emergency order was necessary. This ruling will be used repeatedly in campaign messaging, countering Trump's claims that the prosecutions are witch hunts or politically motivated. The order also threatens Trump's ability to attract and retain competent legal representation. The legal profession relies on trust and ethics, and this emergency order is a stark warning to attorneys everywhere. Lawyers now have to weigh the professional risks of representing Trump. Many highly skilled attorneys may hesitate or refuse, shrinking the pool of capable legal talent. Those who remain tend to be either true believers prioritizing loyalty above judgment, or less experienced lawyers unable to get better clients. Neither inspires confidence for mounting a strong defense. This case highlights a fundamental tension in the legal profession, the balance between zealous advocacy and ethical boundaries. Lawyers are supposed to advise clients honestly, not act as enablers of criminal conduct. Trump has always demanded loyalty above all else, punishing lawyers who follow the law over his wishes. But that approach can't override the legal system. Attorneys who cross ethical lines undermine themselves, their clients, and the courts. This emergency order represents the system pushing back, showing that there are real consequences for crossing the line. The implications go far beyond Trump and his legal team. They set a standard for attorneys representing powerful clients in the future. If lawyers see that unethical behavior can go unpunished, it risks becoming normalized. But this ruling sends a clear message. Privilege cannot be misused to shield criminal conduct. Democracy depends on lawyers upholding ethical standards, even under pressure. When those norms break down, the rule of law itself is at risk. Looking ahead to Trump's upcoming trials, this order is likely to have major effects. Evidence produced under the 72-hour deadline could strengthen prosecutors' cases, potentially showing that Trump and his lawyers engaged in clear obstruction. This would weaken his defense, discredit claims of innocence, and challenge the narrative that these are politically motivated prosecutions. Independent voters, moderates, and even some Republican supporters may take notice of judicial findings about criminal conduct, further damaging Trump politically. The emergency order has also thrown Trump's legal team into chaos. They must respond, decide whether to comply or appeal, and assess their own legal exposure. Some may even consider withdrawing, signaling to the courts and the public that representing Trump has become ethically untenable. This 72-hour deadline means that the next few days are critical. We will soon see what evidence prosecutors obtain and how damaging it may be to Trump's defense. This ruling isn't just about one case or one setback. It's about whether Trump's legal strategy of delay and obstruction is finally unraveling. It's about whether his lawyers will face consequences for crossing ethical lines. It's about whether the legal system can hold a former president accountable despite years of attempts to manipulate it. If the order stands and the evidence is produced, Trump could face devastating disclosures across multiple cases, signaling that the legal walls are closing in after years of using procedural tactics to avoid accountability. Ultimately, this is about more than Trump's personal legal troubles. It's about the integrity of the legal system and whether it applies equally to everyone, regardless of wealth or power. The next few weeks will be crucial in determining whether this emergency order marks a turning point in Trump's legal battles, or whether his team will find ways to resist and delay. The developments are moving fast, and the consequences could reshape American politics and law in the 2024 election.